is on 251st session. It's indeed wonderful to be part of this journey, and on account of the unstable support from all quarters, we are able to forge ahead. Today, in the 251st session, we have a peculiar topic. I got at least 10 or 15 phone calls asking me what exactly the topic meant. So I thought I just keep it a secret, because I'll just require or request the speaker of the day to dwell into that. Constitutional obligations of non-state actors. They were thinking about in terms of Oscars and what you call Filmfare Awards, I think, when they thought about this actors and non-state actors. Today, we are privileged with the presence of Justice Ramkumar sir, Justice Ramakrishnan sir, and all of you wonderful participants who have been part and parcel of this journey of discovery, enlightenment, and empowerment. Today's speaker is a family member who has been a supporter of this platform from, for quite some time, in the sense like he has been giving us leads to good speakers. He has been, in fact, his wife has addressed us on one occasion as well. Sri P.V.S. Giridhar sir is an advocate of High Court of Madras. The profile has already been circulated among the members, so I don't want to take time on that. So this being a thoroughly informal platform, and wherein we only discuss and deliberate on issues at hand. Straight out to you, Giridhar sir. All yours.
Thank you, Shyampadmanassociates. It's an honor and privilege to be here, since most of you are jurists and advocates of eminence. I don't think I'm going to say something that you don't already know. What I'm going to probably contribute to or aspire to contribute to is a new way of looking at the Constitution, whose provisions most of us are familiar with, and hopefully from that we'll have a few insights which will further the cause of constitutional democracy. If I have done that, then my objective in handling this session is over. So I'll start by sharing the screen. Give me 1 minute, please. Meanwhile, I acknowledge the presence of one of my close friends and classmate, Ramesh, with whom I've been studying from school days. He is the president of a leading company, Agilsys in US. He's not a lawyer, but he's here out of his interest. Thank you, Ramesh, for joining us. Can you see the screen?
Oh, yes. Yes.
All right. Thank you. Just 1 minute. Okay. We'll start with a primer on Constitution and Constitutionalism before I actually tell you what exactly are non-state actors. In the course of the second or third slide, it will become clearer. So please bear with me. So one of the first definitions of Constitution and Constitutionalism is political organizations are constitutional to the extent they contain institutionalized mechanisms of power control for the protection of interests and liberties and citizenry, including those that may be in minority. Controlling state constitutionalism from ancient Athens to today, Harvard University Press. William Hamilton noted that constitutionalism is the name given to the trust which men repose in the power of words engrossed on parchment to keep a government in order. Granville Austin has said Indian Constitution has established political democracy and imposed on state the obligation to transform itself into social and economic democracy through peaceful means and rule of law. Oh, these are broad statements about Constitution and Constitutionalism. You will notice that much of it is premised on institutions and power and control. And also there's a slightly milder, if not equal, emphasis on liberties and interests of citizens. So everybody accepts that the Constitution exists broadly for the interests and rights of citizens, but we understand the Constitution as a document which is an instrument of governance, and therefore most of the time Constitution concerns itself with formal institutions of governance, including the judiciary, the executive, the president, the council of ministers, the parliament, and so on. So, trying to move to the next slide.
I think tab, just press tab. I think,
Tab. No, I think I'm going to, should I stop sharing and share once again?
You just, again, try it. I think it'll happen. Might be it got stuck.
No, it's not happening. Give me a minute. We'll stop and share again. So let me keep it like that without going into
Yes.
full screen mode, and then we are able to do better.
Fair enough. It's clear.
Okay. Now, so we'll start with Dr. Ambedkar's address to the Constituent Assembly on 25th November 1949, which is closely linked to this presentation, or the objective of this presentation. He said, on the 26th January 1950, we are going to enter into a life of contradictions. In politics and law, I have added law, we will have equality, and in social and economic life, we will have inequality. Obviously, Article 14 talks about equality before law and equal protection of laws, which is only formal equality. In politics, we will be recognizing the principle of one man, one vote, and one vote, one value. In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one vote. How long shall we continue to live this life of contradictions? How long shall we continue to deny equality in our social and economic life? If we continue to deny it for long, we will do so only by putting our political democracy in peril. We must remove this contradiction at the earliest, or else those who suffer from inequality will blow up the structure of political democracy which this assembly has so laboriously built up. About 70 years later, we are looking at this statement of Dr. Ambedkar, and I wonder how prophetic he was. And as for the last statement, that those who suffer from inequality will blow up the structure of political democracy, never did we imagine that it will be in this manner. We always imagined that there would be some reform and revolution where the poor will have better life, and there will be greater access to education, health, and other opportunities to most of the citizens and most of our children. But despite several initiatives like the Right to Education Act and NREGA and so on, we are still far behind in providing political and social equality or social democracy as Dr. Ambedkar envisaged. And today, there's some kind of counter-revolution where we are going on a reverse trend. And unfortunately, the masses are mobilized in that direction. They think building temples and statues are more important than building hospitals and schools, even though today we have seen how important hospitals are post-COVID. If you look at the origin of the state, a little political theory is important. Unfortunately, many law courses do not teach political theory. Fortunately, I have done political science before becoming a lawyer. And this is precisely what, in the Politics and Ethics of the Indian Constitution, edited by Rajiv Bhargava, he says how important political theory is to understand Constitution. And in the course of that, originally we all know that the state was, in Western political philosophy, was political theory, the state was a kind of a divine creation. What was preached was that the state law was God's law on earth, and the sovereign was a representative of God on earth. That was the justification given for kingship, and that is why people obeyed king's law. because if king's law was disobeyed, it was equivalent to disobeying God's law. Then from that came social contract in the 17th and 18th century. Three philosophers, Hobbes, Locke, and Rousseau, said it has nothing to do with God. The state or the king is there because you entered into a social contract where you asked the king to provide you with protection from internal dissension and disorder and against external enemies, and you surrendered certain liberties. And among them, Locke said, although you surrendered liberties, you did not surrender what are called as natural rights. And natural rights are something which are inalienable. And even in the social contract, we have not surrendered those natural rights, which today we know as human rights or fundamental rights in the context of our constitution. And pursuant to social contract theory of Hobbes, initially justified or legitimized monarchy of Charles II. By and by, we came into an oligarchy, mostly in Europe, I'm talking about. And then gradually, democracy came in thanks to the French Revolution and the American Revolution and other revolutions, post-colonial revolutions in like the nationalist freedom struggle in India and other third world countries. So when Ambedkar talked about, there's one slide I missed out. I just want to, no, sorry. Okay. Now, when you look at tyranny, we are talking mostly of the tyranny of the state and the constitution as a bulwark against the tyranny of the state and its total control and absolutist tendencies. But then the state exists in society and law. And Ambedkar pointed out that it is not only the state which practices tyranny, society can be equally tyrannical. And in the context of our caste system and patriarchy and certain patriarchal tendencies which are inherent in society down the history, whether it's the treatment of Shambhuka in Ramayana or the treatment of Sita by Rama, or several such examples even in Hindu mythology, not to speak of other religions like Christianity or Hindu. In almost all religions, this is prevalent. The tyranny of society is equally absolute as the tyranny of the state, and Ambedkar says the tyranny of society is even harder to resist. I'll come to why I'm stressing on this. The reason is that when we talk of the Constitution, most of the time we are talking about liberty or protection of rights as against the state, which in today's context is not sufficient because there are many institutions and bodies which are much more powerful than the state and governmental institutions. So if there is a asymmetry of power and some people hold power, then a constitution which merely protects you as against exercise of state power is weak and can be ineffective in most situations. So it's important to conceive of constitutional obligations not just of the state, but other individuals who are not traditionally thought of as part of the state. That is the context in which I am talking about non-state actors. So who these non-state actors are, we'll see by and by. Now coming back to the secularism is understood as a basic structure of the Constitution as the Supreme Court stated in Bommai case. You may wonder why I'm stressing on all this. Please bear with me, you will find the relevance in the near future. Okay, if you look at Western political history, you find that there is a struggle between the king and the pope, or the church and the crown, and gradually the church, the king or the state freed itself from the stranglehold of theological grasp, and kingship became independent and the church was independent. Initially, the church was happy with this secularism because they thought that if it is secular, the king will not interfere in our affairs. So it was some kind of mutual exclusion. Now, this is there in Western history. Secularism was a clear trend. In fact, an event spread across several centuries or at least several decades, which happened, which was parallel to the emergence of rule of law and democracy as an institution. So when liberty is talked about, it is not merely liberty from the state, but also liberty from the clergy, which you will find in the French Revolution very distinctively. On the contrary, in the Indian tradition, I am not able to see any great resistance against the power of religion, power of God, or power of church. Since most of you are from Kerala, I am very intrigued by this Mahabali's versus Vamana, episode on the basis of which you people celebrate Onam. If you look at that myth, it says that Mahabali was a very popular leader who was admired and celebrated as a just and king who had the welfare of his subjects at heart. But then this kind of provoked the jealousy of the Devas, and they went to Vishnu and said, "This is a king who must be controlled, otherwise he may become more popular than us." Please correct me if there's any inaccuracy in my statement of the story. Then Vamana, Vishnu takes the shape of a Brahmin, dwarf, comes down and asks Bali for 3 boons, which he readily grants. He says, "I want three spaces of land." So the first space is across the land, the second space is across the sky. He has covered everything. The third space he asks, he offers his head, and he is pushed down to Patala. Now this is, and I believe that once every year he comes out to greet his subjects, and that is what is celebrated as Onam. But then, looking at it as a political theorist, I find that this was a battle between the state and the church, or state and religion, where religion won with meek submission by the secular authority. He did not even put up a fight, because there was an ideological submission where he said, if you want my head and remove me from my kingship, I willingly go down to the Patala. And there's also a caste dimension, because Vishnu chose to become, come in the form of a Brahmin to suppress the king, a secular king. So ever since then, in Indian history, it looks to me, I have not studied history in that great detail, but having read up a little, I find that there is no corresponding tendency of a church versus state battle in India, and therefore the secularism that we inherited on the eve of independence was not as strong historically. It was not born of a history from the pangs of history as of a genuine battle, but rather as need of the Congress to claim that it represented all religions, Hindus, Muslims, Christians, Parsis, etc. And the national struggle itself was waged as a battle of all religions, all castes, all communities, while the asymmetries of power and access to resources was kept at a minimum. That contradiction and inequality was not stressed, but the national national passion to get rid of British shaped our political history and our constitution. And it is in that spirit that secularism was also, we came to inherit secularism, which is actually a very positive thing, but it apparently was more a fashion statement, as Mukul Kesavan says in his Secular Common Sense. Secularism was a fashion statement for the upper middle classes and the elite of Indian society, and once it went out of fashion, they clearly shed it. Now, if you look at the French Revolution, for instance, before, when Louis XVI was there were 3 estates which advised him. One was the estate of the nobles, who were relatives of royalty. Second was the estate of clergy, who were priests. And third was the estate of commons, who were mostly merchants and traders, and probably some big farmers, not the common people. Now, one of the demand, the clergy also drew like land revenue, they drew tithe. 1/3, 1/10 of the produce of all the farmers had to be given to the clergy. So the peasantry and the masses were as angry with the church as they were angry with the king. And they fought against both, and they asked for a common estate. They did not want separate estate of the king or the clergy or of the commons. They wanted a common estate, and they said, let us all meet together, which was, although the king initially agreed to that, later he went back, and that is how the French Revolution happened. So the point is, when the slogan liberty came, it was not merely liberty from the king. It said liberty from the king and liberty from the estates, which is basically liberty from the clergy. So the point I'm trying to make is, when French Revolution happened as the birthplace of democracy and constitution, in a sense, it happened not merely as a rebellion against state power or the king's power. It happened as a rebellion against the nobility and as a rebellion against the church also. So this is the history and genealogy which we tend to forget today when we talk about constitution and constitutionalism, and that is the context in which I am speaking today of non-state actors. So this is what Dr. Ambedkar says. Dr. Ambedkar says, so he aspires for, he talks about the Constitution as a transformative document, hopefully, which will eventually establish social democracy. What does he say social democracy? How does he see social democracy? Social democracy, he says, the way of life, recognizes liberty, equality, and fraternity as the principles of life. These principles are to be treated as, not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. If you look at it, liberty and equality come easily to most of us. At least in theory, we are able to see liberty and equality. Equality we are talking, but fraternity is where the fracture is. In a society which is ridden by, society which is ridden by caste divisions and other religious divisions, and by patriarchy, where most women continue to be suppressed and kept inside their homes by the patriarchal structure, fraternity is not easy to come by. It is no wonder that when everybody agrees that racial segregation is bad, caste segregation is bad, why is it that co-educational schools are not compulsory in India? Sexual segregation is practiced in an abject way in the schools and other institutions in India on the premise that it's not good for young boys and girls to mix. And we are shy and squeamish about taking that. According to me, the Right to Education Act should have compelled every institution, education institution, to have co-education so that the segregation of the sexes ends. This is my take on segregation. Now, if you look at the Constitution, we can conceive of it in two ways. As an instrument of governance, this is how we conceive of it, and this is how I read about when I read about the Constitution in Law College. I saw it as an instrument of governance. I saw what what the powers of the president are, what the powers of the Council of Ministers in a state were, what the Article 246, 7th Schedule, etc., and Article 226 rights. What are the powers of judiciary? So there was, and of course, I knew that there are fundamental rights. Some citizens can exercise fundamental rights, but largely I saw it as an instrument of governance. But by and by, Ambedkar and other Ambedkarite scholars like Gautam Bhatia and many other young people have been talking about the Constitution not merely as an instrument of governance, but as an instrument of social transformation. And there is transformative potential in the Constitution if we look at various provisions in a granular way. That is the context in which I believe that the Constitution embodies several obligations on non-state actors, which are underemphasized in most formal practices of law and even in the popular understanding among lawyers and scholars. For instance, do professions have a constitutional obligation? If you notice, most of you would know that the lawyer's profession is the only profession mentioned in the Constitution, Article 22, which says every person arrested has a right to a legal practitioner of his choice. So that read with Article 39A shows that as a lawyer, since there is my services are a right to a person whose liberties are in danger, which means I have a duty to uphold the liberties of citizens under the Constitution. And I have a duty to, within my role, perform the duty of equal justice under Article 39A of the Constitution. That is how I would read. So therefore, it's not true that Constitution only places obligations on the President, the Parliament, and the High Court, or even District Court, but it is there on common citizens as well. If right to healthcare is a right guaranteed under Article 21 of the Constitution, so on medical professionals and hospitals, there is a constitutional obligation. Let us look at Constitution not merely as one that is an instrument of governance, but as a document which regulates conduct of social relations. Let us look at different social relations. One set of common way of looking at the Constitution is that it regulates the relationship between a state and citizen. Popular among this is Article 16(1), which guarantees the right to equality in the matter of employment under the state. Article 19(1) guarantees various freedoms, including right to religion, right to practice one's profession, right to freedom of expression, right to association, and so on, right to reside in any part of the territory of India. But 19(2) to 6 empowers the legislature to frame a law to restrict these freedoms on certain grounds. Similarly, if you look at Article 51A, it imposes certain fundamental duties on citizens, including the duty to have a scientific temper, to have compassion to animals, to honor international law, to honor and live by the ideals that inspired our freedom struggle, and so on. Now, corresponding to the duties are certain rights. If I have a duty, I have a right to do that duty, and any state measure which imposes hazards or obstructions in the way of my performance of the duty to exercise the scientific temper, for instance, or the spirit of humanism towards all citizens, regardless of religion or caste, then that is a unconstitutional obstruction. Article 297, I will come to a little later. Article 297 is okay. 297 says that all resources, including minerals, etc., which are below the surface of the ocean, within the continental shelf and the economic territory, which is in the ocean, vests in the Union. And the Supreme Court has held that such resources under the sea and also resources which are natural resources vest in the Union on behalf of the people of India, and they represent a public trust, and has evolved the public trust doctrine, which is very important in respect of constitutional obligation of non-state actors, which I'll deal with in some detail at a later stage in this presentation. Next, you have state versus persons. All of you know that not all rights are available to, rights are not available only to citizens. Some rights like 16(1) and 19(2) are restricted to citizens, but Article 14, which guarantees the state shall not deny to any person equality before law or equal protection of laws, which means natural persons, aliens, foreign citizens, etc., are assured of the protection of Article 14. Similarly, 301 talks about freedom of trade.
Why a question mark there?
Sorry?
301. Why a question mark in 301?
Probably it's a full stop.
No, it's a comma. I don't think it's on my presentation. It's a comma.
Oh, see.
I don't know. Do you see it as a question mark?
Question mark. Yes.
Yeah. I'll come to that. Person citizen. Okay. Correct. I'll come to that. Anyway, 301 is the right to. It's about the freedom of territory, freedom of trade throughout the territory of India. Then state versus state, different branches. Article 246, for instance, talks about the division of legislative powers between center and state. Article 72 talks about executive power between the center and the state. And 226 talks about issuing writs to any government. So therefore, several provisions are there which delineate the relationship between different branches of the state. State versus non-state institutions. Okay. See, there are several. One of the features of our constitution is that the constitution itself recognizes several non-state institutions, like the Public Service Commission, Election Commission, Scheduled Caste, National Scheduled Caste Commission, etc., are institutions which are not typically state institutions, but they are today coming to be known as fourth branch institutions. Fourth branch institutions, today legal scholars are saying that fourth branch institutions are very important, and they are institutions which help to institutionally mediate and implement some of the rights and safeguards that are there in the constitution, and their role cannot be underemphasized. For instance, Gautam Bhatia has recently argued that the Right to Information Act, the Information Commission, Central Information Commission, although it is a statutory body, it has been enacted in implementation or enforcement of the right to information available under 19(1)A of the Constitution. and therefore it's a constitutional body. Such a constitutional body, which is set up to mediate and implement a constitutional right, once it is set up, you cannot dilute its powers, is one of the powerful arguments that Gautam Bhatia and others are making. So we'll deal with the fourth branch a little later. So 324(5) is talking about the Election Commission's powers. Okay, Election Commission, in fact, during the conduct of election, is one of the most powerful bodies because it has the power of superintendent, and Supreme Court has time and again emphasized that the power of superintendence is a power which is a composite power, which includes legislative, executive, and even quasi-judicial powers, like no other institution under the Constitution enjoys. Then you have 148(5) of the Comptroller General, Comptroller Auditor General, 5 and 6, his powers. Persons, okay, now here I come to persons versus citizens and persons citizens. Okay, why 301 question mark, I'll explain. You take Article 21. Article 21 is not an injunction against the state. It says no person shall be deprived of his life or personal liberty except in accordance with procedure established by law. So therefore, it does not say the state shall not deprive liberty. Unlike Article 14. Article 14 says state shall not deny to any person equality before law. However, Article 21 says no person shall be deprived of his life or personal liberty. In other words, you will find that this is a right available not just against any state. It is a right against every person who holds the power to potentially deprive you or restrict your liberty. And that is why the writ of habeas corpus is available against a private person. This is very important because later in my presentations, I'll be dealing with the rights, constitutional obligation in places of worship, constitutional obligations in place of employment, constitutional obligations of educational institutions, and so on, where this clarity of exercise of Article 21 as against non-state institutions will become clear. There are any number of examples, but unfortunately, we have not formulated it theoretically in that manner. Okay, 25(1) talks about freedom of worship. Again, freedom of worship does not say that it is, if you freedom of right to practice religion, it does not say state shall guarantee that. It says every person has a right to practice and profess any religion or freedom of conscience, etc. Therefore, I would argue that is a right available not just against the state, but against every other person who holds the power over my religion. So if I'm a major and my father wants to control me from converting to Christianity if I believe in it, then he is interfering with my right to practice religion. Actually, it was something like this was contemplated in the Sabarimala judgment of Justice Chandrachud, which I will be dealing with. So if 25(1), it can, if, for instance, if certain dharmakartas of a temple say that a non-Brahmin cannot become a priest in a temple, then that is that's an infringement of the right to practice and profess religion of a non-Brahmin. So therefore, these rights are not merely against state and state bodies and state institutions, but against all people who hold power in that particular space. If I'm talking about fundamental rights in the sphere of religion, then we need to see what is the power structure in religion. Who are the people who exercise formal and informal power in that space? So in a temple, it's the dharmakartas or the trustees. Or for instance, in Chidambaram temple, it's only certain kind of Brahmins who can become priests. So they hold power. So there was a time in the 1930 to 1970s where temple entry movement was there, where certain communities, including women, even recently in Sabarimala, fought for temple entry, mere entry to worship. But that is not sufficient. What about the right to become a priest? Today in the church, in Western countries, people are talking about the rights of gay people to become priests or even the Pope. But why is it in India today, even today, it's such a struggle for a non-Brahmin or a woman to become a priest in a mainstream temple? No doubt, several people cite that in village deities, there are local temples where women are priests and Dalits are priests, non-Brahmins are priests. But what about the bigger temples? All right. Now why I 301, why I put a question mark is that 301 says freedom of trade. Trade shall be free throughout the territories of India. Okay. Throughout the territory of India, and there shall not be artificial barriers between one state and another. Now I have put it under person stroke citizen versus person versus citizen. So when this freedom of trade is not couched as an obligation on the state, isn't it true that suppose there are some hoarders, there are some people who monopolize certain commodities using their economic and other powers? Will it not be a violation of Article 301? 301 potential has not been fully tapped. We are stuck in the old mode of formal interpretation of Article 301 as a prohibition against state from imposing certain taxes or certain restrictions on movement of food and commodities and other goods from one state to another. We need to enlarge the jurisprudence of Article 301. That is why I put a question mark there. Justice Ramkumar, have I answered your question? Thank you. Now, we are not, when we are looking at the Constitution, we are not merely talking about citizen versus state and person versus state and person versus person. We are also talking about social groups. Our Constitution is an exception from the American Constitution and Western constitutions in the sense that this Constitution does not merely talk about rights of individuals and rights of citizens, but talks also of religious groups, social groups, like untouchability is an offense prohibited under Article 17. So the Constitution recognizes the rights of Dalits or Panchamas who are outside the formal four-caste system to get integrated. That is not just an expression of the objective constitutional value of equality, but one of fraternity. There are several, there is a judicial emphasis on equality, but on fraternity, unfortunately, there is not that equal emphasis, except perhaps in the Sabrimala judgment today, which is being subject to review thanks to the backlash of various people. A simple thing like a woman's entry into a temple cannot be stomached. So what are these rights? Article 15.1, 15.3, 25.2, 39, 335. Actually, I am very fascinated. Okay, so these are 15.1, for instance, says that educational institutions which are maintained by the state you cannot have religious instruction in them. And 25.2, it's about right state. 1 minute. (25.2) says, nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or secular activity. So, in 25.1 guarantees the freedom of religion, but 25.2 says that the state can regulate political, economic, and secular activity associated with religion. Then B, it says that a state can make a law providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So therefore, temple entry is one objective and a facilitating provision made under 25.2, thereby the state facilitating social groups to have access to temples and access to religious resources. Let me put it in a more popular way. So therefore, the fact that most of our many of our fundamental right provisions have a subclause or have a subsection, subarticle providing for the state's role in either interfering with that right or facilitating that right, has restricted our thinking from pursuing the full ambit of the first right. For instance, 25.1 says, subject to public order, morality, and health, all persons are equally entitled to freedom of conscience and right freely to profess, practice, and propagate religion. It does not say state shall guarantee. It does not say state shall not interfere. It says all citizens have. It's almost couched like Article 21, but subject to public order, morality, and health, and to other provisions of Part 3. So wherever there are other rights under the Constitution, then 25 will have to yield to it. So Therefore, I would submit that I would argue that Article 25 is not merely a restriction against the state, but against all religion. So I'm an atheist. There is freedom of conscience. So it is important when I assert my way of expressing my beliefs that should not be interfered by either by the state or by a mob or by a social group or social party or a cultural organization. Then you have social group versus social group. Article 17 is a very important right which prohibits untouchability, where untouchability is an offense where the other non-Dalit, all other communities are prohibited from treating Dalits as untouchables. So they shall acknowledge them and fraternize with them. That is what Article 17 says. Article 15.2 is a fascinating article which I am very intrigued by, and I think that we have not really explored the full potential of 15. If you see 15.2, it says, no person shall on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, or restriction or condition with regard to access to shops, public restaurants, hospitals, places of public entertainment, wells, tanks, bathing gates, roads, and place of public resort maintained out of state funds or dedicated to the use of general public. So therefore, you see a whole lot of places which are non-state-owned places, like hotels, public restaurants, shops, tanks, bathing ghats, roads, public place of public resort, public entertainment place of public entertainment cannot have discrimination practiced on grounds of religion, race, sex, etc. So this is not an injunction against the state; it's an injunction against all people who are property owners or people who control or lease such facilities. They cannot practice social discrimination. Often people think that Article 17 is the only such right that protects Dalits, but it does not restrict other people. No. Article 15.2 is a right which is guaranteed to all religious minorities, all people of all races, caste, gender, place of birth, or any of them. Then you have rights which regulate relationship between social groups and persons and citizens. Again, 15.2 is one, and Article 301 is another. Article 301 can be between traders and consumers. It can be between manufacturers and consumers. Social groups, different social groups. Similarly, 15.2 can be, a cinema theater and cinema goers, audience. So it can be different social group. Now let us look at what are the non-state bodies under the Constitution itself. I already mentioned that Article 22 recognizes the profession of law. But besides that, Article 22.4 talks about an advisory board which has to authorize any public preventive detention beyond 3 months. The Comptroller Auditor General has powers to audit public bodies, including state agencies and state bodies, under Article 148 to 151, and he enjoys, once appointed, he enjoys the security of a Supreme Court judge. He cannot be unseated. Then you have a Finance Commission in Article 281 to regulate the distribution of tax resources between the center and various states. Then under Article 307, interestingly, no authority seems to have been constituted yet. There is an authority for ensuring freedom of trade, commerce, and intercourse, which the president is empowered to appoint to implement the free trade provisions under that part. Public service commissions are to be consulted for appointments under the state, both the Union Public Service Commission in case of senior appointments in the center, and State Public Service Commission in case of appointments in the state. Of course, there is the lower category like Group C and Group D staff can be exempted from Public Service Regulation Commission scrutiny by regulations which can be framed by the President or the Governor, as the case may be. Election Commission is one body, Article 324 to 329. West independent powers. Once an election is notified, the election commission takes over, and even the collector and the local police superintendent or DGP are answerable to the election commission. Administrative tribunals, which is, by the way, is not there even in Western countries. Even in US, for instance, you saw how George Bush won the election, though he had a minority compared to Al Gore, and yet he succeeded because there was no independent election commission. Administrative tribunals by Amendment 323A for service matters of government servants, and 323B for a variety of subjects like trade, commerce, environment, etc., can be appointed, and these tribunals exercise powers like the High Court. National Commission for Scheduled Caste and Scheduled Tribe, 338 and 338A. Special Officer for Linguistic Minorities is contemplated under Article 350. So these are non-state bodies which are there under the Constitution already. You don't have to search outside the Constitution for non-state actors. Then more recently, you have local bodies, which are almost the third tier of government. So Part 9A and 10 have been brought in as the amendments to the Constitution. And under 243I, there's a Finance Commission, which looks at the resources that have to be made available to local bodies. 243G and 243W are 11th and 12th schedule, which set out subjects for which the local bodies can be empowered and financed. And they are envisaged as institutions of self-government, and they are empowered to plan for economic development and social justice. It's very important that the local bodies have clear objectives. Their plans, they are in charge of framing and implementing plans for economic development and social justice at a local level. So while we are talking about global ease of business rules and competition commission, we are setting up various institutions and giving tax concessions and providing infrastructure for foreign investment, there is a provision under the Constitution to ensure that the local players, local economic players and commercial players, including those in the SME sector, are afforded those facilities, provided we appoint and engage resourceful and people with vision at that level. Then under Article 371, there's a special development board for Vidarbha, Marathwada, rest of Maharashtra, Saurashtra, Kutch, and rest of Gujarat, and also for Andhra Pradesh and certain others. Though a lot of hue and cry is made under about Article 370 for Jammu and Kashmir, there are almost equivalent provisions for Nagaland and Assam and many other states, including Andhra Pradesh, about which very few people talk about. One more provision I wanted to show you. 1 minute. Okay, I don't know how it's missed. There is an institution called Industrial Township, which is carved out under Part 9 and 9A, which I think I'll come later, which is exempted from having a local body of its own, which, like some of your smart cities and for instance, the information technology city, in IT city in Bangalore and Hyderabad, etc., they are industrial townships, not amenable to local governance rules. So why are fourth branch institutions important? Fourth branch institutions, according to Gautam Bhatia and some of the leading contemporary thinkers on democracy, they are guarantors of constitutional democracy. Some examples are Information Commission, Election Commission, Ombudsman, such as, for example, South Africa's Public Prosecutor or India's Controlled Auditor General are examples of such bodies. Their importance lies in the fact that as far as certain fundamental rights are concerned, their effective realization is impossible without a kind of institutional mediation. I have personally witnessed in Tamil Nadu, for instance, some of us were doing a lot of work in the State Legal Aid Board. Before the Legal Service Authorities Act came into force, Tamil Nadu had a vibrant legal aid board. And there were a lot of illegal detention cases, custodial violence cases, women who are abandoned, several people who otherwise not have access to justice got access to justice just because of the legal aid board, which can be described as a fourth branch institution. The right to vote, for example, needs an election commission to be realized. Similarly, the right to information needs an information commission, and so on. So we underestimate the importance of such institutions. Of course, those institutions, there are a lot of difficulties with them. For instance, today, National Commission of Human Rights, though an institution, a judge has been appointed whom many say has never upheld human rights while he was holding tenure as a High Court judge or a Supreme Court judge. Then there's a lot of criticism about it. But the fact is that there is an institution for that purpose, and we can critique it and improve it and keep empowering that institution and work through its wheels to realize human rights is a very important issue. And unfortunately, even the left in the country and people who are otherwise popular, defenders of liberties underestimate the importance of these fourth branch institutions. Recently, there was a panchayat president who came to me for a problem in his panchayat, and he wanted me to file a case. And he was complaining that there was a company which was polluting and making a mess of things, and they were not able to. So he wanted to file a writ petition. So I told him, today you are the panchayat president. You are not some kind of local activist. You have powers under the Panchayat Act, issue the show cause notice and cancel their license. He did not know that such a power was available to him. Then I read out and gave him a primer on what he can do. He went back and tried to do that with limited success. The point I'm making is, it is important not just to fight on the streets and to have dharnas and protests, which are important, but it's equally important to get into fourth branch and other state institutions so that we can empower these institutions and pull their levers towards a direction of social democracy if we are interested. Consequently, the independence of such bodies is an integral feature of the complete fulfillment of the right itself. And insofar as issues such as membership and functions of those bodies are to be determined by legislation, such legislation must A, be framed so as to ensure the right is actually realized, B, once framed, attains the status of a constitutional statute. Recently, the Kenyan Court of Appeal gave a judgment relating to an election matter where a delimitation exercise was and constituency framing exercise was carried out without reference to the election commission. The state passed a law bypassing the election commission. The Kenyan High Court struck down that law, saying that although the election commission was a statutory body, it was a constitutional institution, and when you bypass it, that law is invalid. So in the context of that, Gautam Bhatia talks about the importance of such institutions, and he says that it's important. So, for instance, when recently the powers of the Central Information Commission were watered down by amendments by this government, unfortunately, though Right to Information activists shouted hoarse, there was no popular protest at all, and the middle classes cared two hoots what happened. Today, there is a cry about goshalas and temples and etc. But as far as the right to information is concerned, or such constitutional rights are concerned, the concern seems to be on a very low bar. In fact, when the Right to Information Act came into force, many of us were thinking that the first people who would undermine the Right to Information Act would be the bureaucrats, because they would be threatened. But surprisingly, I also practice in CAT service matters, and I find that most government servants have profited from Right to Information Act because they readily get the DPC proceedings, various circulars, various notes of file notings, etc. under the Right to Information Act, which we then as lawyers use for their promotion or better pay and so on. So this is Right to Information is an act which not only institutionalizes and enables the implementation of right to information, but also something which all sections of Indian society have a stake in, though they don't seem to realize it. So let us look at, we are having once again, a look at non-state actors under the Constitution. So you have schools and education. You look at the power holders and resource users. You have the educational agency or the owners of educational institutions on the one hand. Then you have employees, teachers, and students. So the constitutional provisions, Article 21A, guarantees right to free and compulsory education for children from the age of 6 to 14. I won't go into the details, but these are articles which deal with rights in the context of an educational institution. And therefore, when we are looking at these rights, we have to look at this not as one single right, but what are the rights of an educational agency, what are the rights of a teacher, and what are the rights of a student. They are not necessarily the same. Obviously, when looked at from the perspective of the student or the teacher, it will be totally different from the right to education of an educational agency. So including the syllabic content. What about, when today textbooks are being changed, science courses are teaching astrology, and the science of Gomutra is replacing the science of pharmacology. Now, all this are rights. I don't know, but we need to find a way of institutional and constitutional mode of combating these assaults on common rights of people. Then if you look at place of work, you have master and servant, and you have these constitutional provisions, 23 against forced labor, 24 against prohibition of children in factories, mines, and hazardous employment, 41 which guarantees right to work and employment, etc. Place of worship, religious charitable trust institutions. You have trustees, you have the clergy or the priests, and you have the worshippers. So Article 25 and 26 need to be interpreted in terms of the right of each of these sections. They are different. The rights are not the same, not uniform. But since it is only the power holders in each of these institutions who have the resources to approach high courts and Supreme Court, generally the larger generic frame of these rights are in terms of their rights. For instance, if you look at the right to free speech and expression in 19(1)(a), you will find most of the cases deal with media barons. They're about Bennett and Coleman, they're about Z Films, they're about Express newspapers and so on. Owners of media houses rather than about journalists or editors or readers. So if you look at corporations and commercial institutions, you have 19(1)(g), you have the public trust doctrine, which I'll talk about under Article 297. And in the context of industrial citizenships, you have businessmen who control the industrial citizenship. Then you have employees, most of whom are also residents. In this context, I would like to recall the case of Marsh versus Alabama in 1925 in United States Supreme Court, the leading case cited by our Supreme Court also. There was a lady who was Marsh, who was distributing evangelical literature inside a township which was owned by a private corporation. And the forest guards threw her out and framed her for trespassing. In challenging that prosecution, the case went up to the Supreme Court, and the Supreme Court held that when a private township is exercising public functions, it has to abide by the Bill of Rights under the US Constitution. And he said she has a right to practice and propagate her religion, and you are controlling a township, which is normally not the private property, it's a sovereign state function. And even if a private body is exercising a state and sovereign function, then rights guaranteed under the Bill of Rights provisions of American Constitution are enforceable. A country like US, which is known for laissez-faire and freedom of trade, etc., has come up with that judgment. Should our constitution lag behind? It does not lag behind. This is quoted with approval in Ramana Shetty's case and several other cases. In fact, there was a case which I argued and lost in Spick Township in Tuticorin in Tamil Nadu. There was a Spick union leader who stood for panchayat elections. He was prevented from participating in campaigning within the township by the management. And I filed a writ petition. I had a great difficulty in numbering it, saying that Spick Township is not. Then I cited March versus Alabama. Although the writ petition was held maintainable, the judge ruled against me. But cases like this must be plenty. And as you find gated communities and huge townships and industrial townships coming out more and more, you will find need for these kind of interpretations, because state functions, traditionally conceived state functions, are going to private players in public-private partnerships and so on. So therefore, it is time we start looking at the fundamental rights and other constitutional rights in the context of power holders rather than in state, in terms of state agencies. Now let us look at Article 12 and 226. Article 12 defines state and Article 226 talks about judicial remedies available to citizens and persons at the hands of the High Court. If you look at the definition of state, the state is defined as it includes the under Article 12, government and Parliament of India, government and legislature of each state, and all local or other authorities within territory of India are under the control of government of India. So, but for habeas corpus, all other writs were restricted, saying only if the body is a state agency within the meaning of Article 12. Either the body should be controlled by the state, pervasive control should be there, or the body should have state be funded by the state, then only a writ petition will be maintainable. However, in Aunty Mukta Trust case in 1989, all that changed. I'll come to. So, in Aunty Mukta Trust case was a case where a private trust was running a school and they closed the school down and did not pay salaries to their teachers for about 2 years. So the teachers petitioned the High Court, which dismissed their case, and they went to the Supreme Court. In the Supreme Court, it was argued that this is a private school run by a private trust. So the body is not state under Article 12, so it is not maintainable. However, in a classic judgment, the Supreme Court held that the nature of the body is irrelevant. The nature of the duty cast upon that body is relevant for mandamus, and said that education is a function which is a public function. And therefore, since it is a public function, you are amenable to the fundamental rights under the Constitution, and under Article 21, a right to live with human dignity is guaranteed, and therefore payment of salaries is a public obligation, since the teachers are people who are implementing the right to education guaranteed under the Constitution. Their salaries cannot be deprived. Another argument was that the right to receive salaries is not born of any statute. It's not a statutory right, but of a contract. In that context, Supreme Court looked at university affiliation rules and found that there were regulations relating to pay of teachers and said, no, one, we will still, even if it's a contract, it can still be enforced. In any case, here there are university regulations which govern the pay scales of teachers, and therefore you have to pay them. That was, in my opinion, was a breakthrough. Though as early as 1969 in Praga Tools versus Emmanuel, Supreme Court did say, although in that case they dismissed the case, they did say that even a private body is amenable to writ jurisdiction. Then Dr. Janet J. Paul versus SRM University was an interesting case. I appeared for her in the High Court. He was dismissed in SRM by SRM Medical University. She was teaching, I think, genetics or she was teaching genetics. And she was dismissed on certain grounds without a proper inquiry. The single judge allowed her case and held that the SRM University was a deemed university under Section 3A of the UGC Act and therefore amenable to writ jurisdiction. However, by that time she had a fight with me and decided to argue her own case in the writ appeal. And in writ appeal, a former Advocate General was appointed by the university, whereas she was arguing party in person. The division bench of the High Court, our High Court, dismissed the writ petition, saying that a deemed university is not an authority under Article 12 of the Constitution. Unfortunately, they did not respect the law as prevailing in 2016, that an authority need not be an authority under Article 12. It needs to be only an authority under Article 226, which is different from an authority under Article 12. Then she went to the Supreme Court and fought the case as party in person. And luckily for her, the Supreme Court appointed Harish Salve as an amicus curiae in that case. And in that case, Supreme Court held that deemed university, it may not be an authority under Article 12, but it's an authority under Article 226 since it was exercising a public function, and therefore set aside her termination and directed the High Court to decide the case on merits. Then again, Z Telefilms versus Union of India. If their Supreme Court held, if there is any violation of any constitutional or statutory obligation or rights of other citizens, the aggrieved party may have a relief or by way of a petition under Article 32, but that does not mean that the violator of such right would go scot-free merely because he or it is not a state. Again, in BCCI, which was a suit, not a state body, without determining whether it was an authority under 12 or 226, because it was a state, Justice Khalifullah, bench led by Justice Khalifullah, said, having regard to the enormity of power exercised by the board, it is bound to follow doctrine of fairness and good faith in all its activities. So therefore, that's expanding the jurisprudence, saying the moment a body has a large, exercise huge amount of power, then the enormity of the power imposes corresponding obligations of fairness and good faith. Recently, in an arbitration against NBFC, I argued, in the case of my client's loan was foreclosed, and the RBI has introduced what is called a fair practices code, which every bank is supposed to adopt. And the fair practices code says that the bank shall conduct itself in a fair and reasonable manner with every constituent and customer. So I said every contract should be read in light of the fair practices code. And if there's a contract or a practice which is not fair and reasonable, then the arbitrator should not go by that. The arbitrator disagreed with me, and I went to the Bombay High Court. But and I got a stay. But before that, the case was settled. The point I'm trying to make is that we need to continue to expand the jurisprudence. Sorry. How much time do we have? I have another section where I'm dealing with the constitutional rights in the context of education, in the context of employment, in the context of religion, and in the context of the public trust doctrine on private corporations. These are 4 sections which I want to deal with. We take, so Shyam, you must tell me whether we have time or should we break and have another session. I think it's 6:42. Can I continue? I find people are a little tired.
Shyam is missing.
Shyam is missing.
It-
What do you say,
It
sir?
could be
Yes,
it could be the subject of another lecture, independent lecture, covering all those.
Actually, yeah, I have the continuing slides. I have another 1 minute, about 48 slides, of which I have
Oh,
covered
then
15.
It will be better to have a thorough session. Can be postponed it. That will be better.
We'll
Yes,
have
it is better
second
because
lecture.
I have framed, each provision on education. What are the rights in the context of education? What are the rights in the context of a workplace? What are the rights in the context of private company, etc. So
If we can stop it at one point, then we can continue in the next session.
I think he has already reached that stage. He is going
Yes,
by
yes.
subject wise hereafter.
Yeah.
Okay.
So I can close this and we can
I think
have
for the time being, we'll have it and we'll have a discussion on this for a couple of minutes, and
Yes.
then we'll have it in the next session.
Sure.
So may you go to Ramkumar sir, please.
Thank you, Shyam. Excellent articulation on the 4th branch institutions. A person like Mr. Giridhar, alone having a holistic view of the interplay between the various articles, can cluster them so beautifully. This is how ostensibly teethless creatures can discover the innate power in them, as it happened in the Lokayukta in Karnataka. What is needed is only a discovery of those powers by the body itself. We saw the power and independence of the election commission when the main seat was occupied by Mr. T.N. Sheshan. We saw the independence and power of that election commission, which was until then or hitherto a teethless body. Going by today's caption, my initial response was that it was a dry subject. But you have injected so much interest that I know that more than the name or label for the subject, it is the function of the body which is decisive. Very wonderful articulation, Mr. Sridhar. Thank you. Thank you for the.
Very true, Ramkumar sir. Ramushan sir.
I endorse Ramkumar because nothing more to add, because Sridhar has put it in a different way as to how the non-state holders has also some obligation to do under the Constitution. and you are not expected to go for any other provision which is required for the purpose of understanding what is the responsibility which is already inbuilt in the Constitution itself. But only thing is a lack of knowledge about it. So it is high time for people like Giridhar to educate the persons who has to exercise their right in the right way and do it in a right way. I will underline the words right way. Probably the subject has become more important because of Jai Bhim film, it appears.
Yes, that's true.
That prompted Giridhar to select this subject to find out what are all the obligations or responsibilities of a non-state actors in protecting the interest of the public in that way.
My name is Giridhar, sir.
Giridhar, yes.
Yeah.
Giridhar.
I didn't miss the word, I think so, because you are appearing before me also, I can remember your name.
Yes.
So, and that is how the things have been beautifully articulated with the provisions in the Constitution itself. Though certain things appears to be controversial, don't say that it is controversial. It is still sub judice, pending before the courts as to how this will be dealt with. And I think it's a high time for the non-state actors to take up their role in exercising their right for the purpose of extending their responsibility of protecting the society. Thank you very much, Mr.
Thank you.
Giridhar.
Thank you.
Thank you, Ramashan sir. Let us hear from Ramesh sir. Ramesh.
Yeah, no, thank you. I just enjoy participating here. I'm proud to say I'm a friend of Giridhar for more than 50 years. I know him from the age of 9. He and I were classmates from grade 3 all the way to grade 11. So very proud to be here, and I really enjoyed listening to the conversation. I'm zero in law. I have no clue. I'm not a lawyer, but it was still very enjoyable. Thank you, Giridhar. Just enjoyed being. And it's also 5 a.m. in the morning for me in the US time zone, which when it started. You could have chosen a better time, Giridhar, but other than that,
but I would say you had a good start for the day.
We are looking for that.
Yeah, thank you. Thank you for allowing me to be here.
Thank you, Mr. Ramesh. Yeah. Prasad sir.
Thank you for the opportunity. I feel that a very big searchlight is focused onto the various constitutional provisions, which are, we think that in day in and day out we are reading, but it is a great insight into this. I have a small doubt that under RTA Act, whenever we apply for some replace by the certain clients, the standard answer is that matters are sub judice. Whenever some cases are pending, I find that this is the way they would like to cut short the right, shelve the right or whatever it is. I just wanted our learned friend whether any other remedy is available to pursue this, to see that some kind of information is available so that effectively one can present their case before the legal forum.
Yeah, I don't have the right in act before me, but I do not think sub judice is a ground on which is one of the enumerated grounds on which it can be denied. Is it there?
No, it's not there.
It's not there. So therefore, in my opinion, it is absurd because every matter is sub judice. Tell me one matter which is not sub judice. It's a pendency of litigation. Recently, the Supreme Court, framed an issue which was criticized, where they said whether any person can protest against a law when the court is seized of it. And several people have pointed out that that cannot be so. The right to protest is independent. And the right to challenge a law falls with challenge to a law is only in constitutional terms, which is very narrow. There are various restrictions to judicial review. But as far as the right to protest, you can, even an unjust law, it may be constitutional. Even a law which is foolish may be constitutional. But a citizen can criticize such a law and ask for its repeal. It is a very wide field. And often the judges tell us, your forum is not here. You go to the parliament. Court cannot interfere. Then it is not just so. Therefore, we have to go to the parliament. Going to the parliament does not mean that I have to become a member of parliament, spending crores of rupees or joining a political party, which I don't believe in. But it means lobbying and petitioning my members of parliament and the parliament and constitutional institutions which are existing to ensure that there is a change in law. I don't think I've answered, given you a practical way out, but this is my opinion. Now, to look at it practically, we need to, I think, I mean, you're a senior lawyer, so I don't have to advise you. We just have to point out that sub judice is not a ground, and if it's not enumerated as a ground, he has no business to reject it on that ground.
We can pursue through appeal.
Because it's section 8 and 9, if you see, and you can definitely give an appeal, and that will definitely put them to task.
And why giving the answer, he can also say that matter is pending adjudication before a court of law. But that is no ground to desist from answering.
Because we are not asking for an opinion or anything. It's only off-the-shelf information. So
exactly.
It has to be given. I don't think there is anything. Let us get some domestic opinion also. Swapna ma'am is here. You let unmute.
Yes, sir. So I've been listening.
Except the marital bond, I think she may be having her own independent ideology.
Yes. Yes. My interest is actually maybe when we talk about offices like patent offices and organizations which are run by the government, but at the same time, probably they will come under the fourth, what was that, Giridhar?
Fourth branch institution.
Institutions.
Fourth branch.
Yes, fourth branch institutions. But at the same time, they also have a global context to function. So sometimes they are more in harmony with international standards than with Indian standards. And sometimes that makes them inaccessible. For instance, the cost of filing a patent or for doing some of the processes in intellectual property are actually quite inaccessible to Indians. But at the same time, they are becoming more and more harmonized with the guidelines internationally. So I was just thinking, as you were saying, that it's an interesting discussion to consider. That is one aspect. And the other aspect was when you were mentioning Bali and Mahabali and Vamana. The other story that's interesting is Mahishasura and Mahishasura Mardini. Because in the recent past, there is a lot of discussion in Mysore about having a Mahishasura Divas beside Dasara, where they talk about Mahisha as almost in several different contexts. One as a good ruler who was a Shudra, the other as a Buddhist ruler. And so how the religious majority took it over. So these are the 2 points that I...
You should support it if you are getting one more holiday for that.
That's the best way, yeah.
No, you see, as far as this Vamana and Mahabali is concerned, it is not because of the jealousy, but because of the boon he has got. I think he was trying to...
Boon.
Jealousy also played a role.
Jealousy is always there between Asura and...
It is an intrinsic part of us.
Let us leave all these celestial things to them. Let us think in terms of what's available on earth right now.
Disguised as a midget mendicant, Vamana was actually playing to the tune of the Devas.
There was a concept in Tamil Nadu. All Aryans are Devas, and others were what is called the Asurans were Asuras and Dravidians. So that concept is also inculcating something on Giridhar to look into these and those aspects. I am not on those things now.
And so for that matter, even Ramayana was condemned to a certain extent because it is Aryanization of South India or something was said.
Yes.
About which let us not comment on this platform for the time being. We'll have occasion for that also. We'll also touch. I mean, we are not afraid to touch upon that subject, but not today anyway, because it's past Ramachandran sir's dinner time, it seems like. The only excuse I can say.
No, probably I am the only excuse for winding up the...
No, sir. I mean, at least the finer things of life you teach us to enjoy, like which we forfeit at times. I just envy you. That's why I am saying that. Not because of anything. Rao sir,
it's an item of phototropism.
Not just food, sir. Indulgence in all those things which make you happy. the way he puts the daily, messages, everything, that all reflects on the intelligences he has for having happiness in every day. That's really good. Rao sir, over to you.
Giridhar sir, good evening. Nice to hear you again. I mean, it's a very good subject, especially like for people like me who have dealt with the third instrumentality of the state, which is the public sector undertakings, which I fight every day. That's one aspect. Now, there are certain things that you spoke about, you know, the Dharmakarta of the temples. Even if I want to bring in a reform, the surroundings will not allow me to bring in that reform. And that is basically, as Justice Ramkumar said, is the mindset. Once the mindset is clear, then a lot of things will fall into place. But that doesn't happen. I mean, even in ways of exercising power, as we said, till Mr. Seshan came and nobody was bothered about the election commission. If it came into limelight, it was only thanks to Mr. Seshan, and it lost its glory again. Unfortunately, it has lost its glory. That's number one. This is with the Dharmakarta. Now 15.2 or 15.1. I have been fighting this since 1997, sir. Because in Air India, there is a class discrimination between male and female in the cabin crew. And the Supreme Court in 1984 held that it was not in violation. And I fought against it in 97, culminated in 2010, where the Bombay High Court overruled and said, no more discrimination should be there. But it was overturned by the Honorable Supreme Court, saying that even though much waters have flown, no water has flown. It has remained constant and stagnant, so that discrimination will continue. Of course, we were proud that the president heard us out and an ordinance came and we overcame that thing with that. Now coming to non-state instrumentalities, the biggest problem is the Central Vigilance Commission. I deal with this CVO of Air India on a daily basis because of the amount of corruption that takes place. And you will be surprised that all the CVOs from, I mean, where I have been active 1997 till today, have earned much more from Air India than they have saved for Air India. They have enjoyed n number of trips all over the world, free trips for them and their family at company costs. I mean, they would go for an inspection, the family would follow them. So there has been a misuse. The third, the fourth instrumentalities have there has been no control over them. And if you look at all the posts, they've been headed by either retired bureaucrats. So the saga continues, when in power and out of power. So, I mean, by having all these instrumentalities, as you just said, these are non-state functionaries, but to be honest with you, they are non-state, non-functionaries. And I mean, there is, like as the gentleman asked about the RTI, I mean, the RTI is very clear. He's asking for information. Is that information is there on record? If it is there, you provide it. If it is not there, say it's not available. And what is on record, whether the matter is sub judice or no, that is a public document. It's as simple as that. So this is once again, like I said, out of power bureaucrats come into power in these bodies, and then they interpret the rules as they want to interpret it, and that's what creates the problem for the common man.
Ruling to roost.
Yes, ruling to. Sir, today, where is there a rule of law, sir? Ramkumar sir, honestly tell me, sir, where is there a rule of law? I mean,
honored in their
even the judiciary is hesitant to use its power to its fullest. I mean, we are seeing some correction now, but if you look at the last 3 CGIs, what did we see from them? I mean, they are scared. They are scared of the executive. Why should they be scared of the executive? So basically, it is the mindset that somebody says that I am doing my job. I mean, I don't want to be transferred out of Bombay, so I will not take any harsh decision where I come into the limelight. So ultimately, it is the mindset, sir, for any person. I mean, I am not talking only of a judge. I'm not talking only of a magistrate. I am talking of any person in authority has to interpret the law as it needs to be interpreted. Don't go beyond the scope and don't go under the scope. And that would change a lot of things. I mean, in fact, like when Mr. Giridhar continues, I know it will be more interesting because he's literally dissecting each section, and
Yes.
that would give us a more elaborate view of what is happening. I mean, what I think Mr. Giridhar would be doing now is basically a postmortem on this very forum. And that is the beauty of this forum, is that we can be candid. We can conduct a postmortem, we can go through it, talk about it, and discuss it threadbare. And that's one good thing. And thank you, Mr. Giridhar, and thank you everybody for being here.
I just have one comment. It is not a post-mortem, sir. It's a live body which we are vivisecting without endangering the body politic or the body constitutional, and trying to infuse more life into it.
Okay.
It's a surgery that's happening. Let's see. So we'll continue this most probably subject to Giridhar's convenience next week. Let's finalize the date. Tomorrow in the 252nd session, we are moving away from all this into something that is very, very relevant, in the sense like, not that this is not relevant, but something entirely different. It is Muslim will. And this is
Gift.
Muslim gift. I mean hiba. I'm sorry. That is there are restrictions. There are different. Unlike other religious denominations, the gift that happens in Muslim community is a very interesting topic. Tomorrow at 10:30, we'll be dealing with Muslim gift and overview by Justice Ramkumar sir. So thank you, Giridhar sir.
13th may not be convenient. 20th may be convenient. 13th I won't be in town.
No issues, sir. I mean, Saturday and Sunday is available. Whichever day you can say, we'll continue the session, because so much of interest has been garnished, and we like to have a quietus of that issues, the way in which you would like to present it, and we would like to see it in our own perspective on those issues. Let us have it any day convenient to you, so that we'll continue and complete it. Thank you very much for sharing your thoughts with us and agreeing to continue to complete the session in the next whichever date is convenient to you, sir. And we are privileged, Sir Ramkumar sir and Ramakrishnan sir, for your valuable presence and inputs. And Ramesh sir, thank you for waking up so early, and do wake up early next time also, so that we'll have your valuable presence also.
10:30 will be his bedtime at that time. 10:30 morning will be his bedtime.
That I understand. But let us have different kinds of thoughts. And somebody was saying that I got windows on all part of my apartment, so I get cross pollution. So let us have thoughts and ideas that comes from different quarters, so that we'll also go back enriched. So thank you very much.
Thank God,
again,
thank God not CCTVs. Thank God not CCTVs. All around.
Now, privacy is only in the book. It is so, sir. Till we meet again tomorrow, 10:30. Please do take care.
Thank you.
Thank you.
Thank you, Ramesh, for coming.